Hello everyone, how are you? Let's continue our lesson. We ended here last meeting with the question, are administrative officers tasked to implement the law authorized to interpret the law? The answer is yes. And this is according to the case of PLDT versus NTC. According to this case, administrative agencies and their officers are authorized to interpret the law because they have expertise to do so. This ruling is also used in the case of Nestle versus CA. The previously mentioned case class answered the question, are constructions of administrative officers binding upon the courts? The answer is yes. Such interpretations of administrative officers are given great weight unless such construction is clearly shown to be in sharp contrast with the governing law or the statute. So what happened in the case of Nestle Philippines Incorporated versus CA, GR number 86738, decided on November 13, 1991. So in this case class, Nestle Philippines increased its authorized capital stocks from 300 million to 600 million divided into 6 million shares. Here, the board of the corporation authorizes the issuance of 344,500 shares out of the previously authorized but unissued capital stock. Hence, Nestle Philippines now filed a letter with the SEC seeking exemption of its proposed issuance of additional shares to its existing shareholders from the registration requirement of the Revised Securities Act and from the payment of fee. Now, SEC here replied that Nestle Philippines need to pay a fee for the proposed issuance of the shares. The issue here is whether or not Nestle should pay for the proposed issuance of the shares. The answer is yes. In this case class, they tried to examine Section 6A4 of the Revised Securities Act. Let us read Section 6, Exempt Transactions. The requirement of registration under subsection A of Section 4 of this Act shall not apply to the sale of any security in any of the following transactions. Let us go directly to number 4. The distribution by a corporation actively engaged in the business, authorized by the Articles of Incorporation, of securities to its stockholders or other security holders as a stock dividend or other distribution out of surplus, or the issuance of securities to the security holder or other creditors of a corporation in the process of a bona fide reorganization of such corporation, made in good faith and not for the purpose of avoiding the provisions of this Act, either in exchange for the securities of such security holders or claims of such creditors, or partly for cash and partly in exchange for the securities or claims of such security holders or creditors, the issuance of additional stock of a corporation sold or distributed by it among its stockholders exclusively where no commission or other remuneration is paid or given directly or indirectly in connection with the sale of distribution of such increased capital stock. So when we examine class Section 6A4 of the Revised Securities Act, it will be seen that the statutory phrase issuance of additional stock is ambiguous because it may refer to four things. First, the issuance of the capital stock as part of and in the course of increasing the authorized capital stock, or upon the issuance of already authorized but still unissued capital stock, or upon the issuance of already authorized but still unissued capital stock, or it may either mean newly authorized capital stock issued in the course of increasing the authorized capital stock, or previously authorized but unissued capital stock. Here, the SEC already ruled that the provision refers only to the issuance of shares of stock as part of and in the course of increasing the authorized capital stock of Nestle. Since the 344,500 shares are proposed to be issued from already authorized but still unissued capital stock, and since the present authorized capital stock of 6 million shares is not proposed to be further increased, the SEC and the CA rejected Nestle's petition of exempting them from payment. The court rejects the petition and upholds the interpretation of the SEC. What is the wisdom of this case? It is a well-established rule that the construction of an administrative agency charged to interpret and apply a certain statute is entitled to great respect and should be accorded with great weight by the courts unless there is a clear conflict with its construction with statute or with the Constitution. Always remember, class, that interpretations of administrative officer are given great weight unless such construction is clearly shown to be in sharp contrast with the governing law or the statute. What then is the doctrine of subordinate legislation? The doctrine of subordinate legislation pertains to the power of administrative agency to promulgate rules and regulations on matters within their own specialization. What does this mean? This means, class, that administrative agencies are entities within the executive branch of government tasked with implementing and enforcing laws passed by the legislature are agencies which possess expertise in specific areas such as healthcare, transportation, finance, and environmental protection. And these administrative agency class, as part of their functions, they are empowered to create rules and regulations often referred to as subordinate legislation or delegated legislation. These rules and regulations are intended to provide detailed guidance on how the laws passed by the legislature will be implemented in practice. But what is the scope of the doctrine of subordinate legislation? This doctrine, class, recognizes that administrative agencies have specialized knowledge and expertise in their respective fields. Therefore, they are best suited to develop regulations that are tailored to the complexities and nuances of their respective areas. And like other branches of the government, which are also tasked to create their own rules and regulations, administrative agencies are also expected to follow formal process, which typically includes public notice, comment periods, and approval by designated officials or bodies within their own agencies. This process ensures transparency, accountability, and public participation in the rule-making process. However, the doctrine of subordinate legislation is not unlimited. It is subject to certain constraints such as adherence to the enabling statute that defines the agency's jurisdiction and objectives. Additionally, the exercise of rule-making authority may also be subject to oversight by the legislature or the judiciary to ensure regulations are consistent with the intent of the law and do not exceed the agency's statutory mandate. So why are our administrative agencies delegated with such power to create their own rules and regulation? When in fact we follow the non-delegation of powers. What does it mean? The non-delegation doctrine stands for the principle that Congress cannot delegate its legislative powers or law-making ability to other entities. Because you know what is delegated cannot be delegated. Remember the Latin phrase, delegata potestas non potest delegari? Which is a principle in the Constitution and administrative law that means no delegated powers can be further delegated. But what is the reason behind giving administrative agencies the power to make their own rules and regulations in implementing the law? Always remember this, that while the making of laws is a non-delegable activity that corresponds exclusively to Congress, nevertheless, the latter may constitutionally delegate authority to promulgate rules and regulations to implement a given legislation and effectuate its policies for the reason that the legislature class often finds it impracticable, if not impossible, to anticipate and provide for the multifarious and complex situations that may be met in carrying the law into effect. While it is true that one to whom power is delegated cannot himself further delegate the power, because the rules and regulations they make, class, is a way to make sure that government agencies follow rules and guidelines when carrying out their actions and operations. Administrative agencies are usually given broad powers to investigate and set their standards and enforce those standards in their respective agencies. What then, class, are the limitations on the doctrine of subordinate legislation? We have rule-making power. It cannot contravene a statute or a constitution. It partakes the nature of a statute where rules are not laws but have the force and effect of laws, and it enjoys the presumption of legality. Let us discuss these things one by one. While they have the power to make their own rules, the rule-making power is also limited. While agencies, class, are authorized to create rules and regulations within their specialized areas of jurisdiction, they must do so within the bounds of their enabling statutes. Agencies cannot exceed the authority granted to them by law or engage in rule-making that goes beyond the scope of their statutory mandate. Second, it cannot contravene a statute or a constitution. Of course, we all know this general rule. All laws must abide to the supreme law of the land. Subordinate legislation, such as rules and regulations issued by administrative agencies, cannot contravene existing statutes or provisions provisions of the Constitution. These rules must be consistent with the higher laws of the land. If there is a conflict between a rule and a statute or the constitutional provision, of course, what will prevail? The Constitution itself. Otherwise, the rules and regulation that you made may be declared invalid or unenforceable. Another limitation on the doctrine of subordinate legislation is that the rules and regulation must partake the nature of a statute, meaning rules are not laws but have the force and effect of laws. What does it mean? While rules and regulations issued by administrative agencies are not statutes enacted by the legislature, they have the force and effect of laws within their respective domains. This means that they are binding on the parties subject to them and carry legal consequences for non-compliance. However, unlike statutes, rules and regulations are subject to more expedient modification or repeal by the issuing agencies. Lastly, the rules and regulations promulgated by administrative agencies enjoys the presumption of legality, meaning courts and other government agencies should generally respect and apply them unless they are declared invalid through proper legal proceedings. This burden of proof falls on those challenging the validity of a rule or regulation to demonstrate its unlawfulness. What then is the concept of contemporaneous construction? Construction is placed upon the statute by an executive or administrative officer called upon to execute or administer such statute. These interpretative regulations are usually in the form of circulars, directives, opinions, and rulings. So even when contemporaneous construction, while in no case binding upon the courts, it is nevertheless entitled to great weight and respect in the interpretation of ambiguous provisions of the law unless it is shown to be clearly erroneous. When we say contemporaneous construction class, this refers to the interpretation or understanding of a statute or law by an executive or administrative officer who is tasked with executing or administering the statute. In other words, it is the interpretation placed upon the law at the same time of its enactment or implementation by those responsible for enforcing it. It is important to note that contemporaneous construction is not binding on the courts. Judges retain the authority to interpret the law independently and are not bound by the interpretations provided by executive or administrative officers. However, courts often give considerable deference to contemporaneous construction unless they are shown to be clearly erroneous. So the guiding principle behind giving way to contemporaneous construction is to promote consistency and coherence in the application of the law. By considering the interpretation of those responsible for administering the law, courts can ensure that judicial decisions align with practical realities and policy objectives intended by the legislature. So always remember, contemporaneous construction refers to the interpretation of a statute or law by executive or administrative officers involved in its execution. While not binding in courts, this interpretation is entitled to significant weight and respect, particularly in cases of ambiguity, unless it is demonstrated to be clearly erroneous. This ends our lesson number 2, and please answer the exercises that I shall be giving you. Have a great week, and thank you for complying your case digest.